Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
Now Dennis, one of the leading cases last week concerned the government pandemic policies on discharges of hospital patients to care homes. What did the case decide?
Well, yes, Helen, the courts have now determined that the government policies during the early stages of the pandemic were irrational and therefore unlawful. Here's the detail. In the Crown on the application of Gardner against the Secretary of State for Health, the court found that government policy in March and early April 2020 was irrational because it failed to take into account the risk to elderly and vulnerable residents from non-symptomatic transmission. On the 17th of March 2020, the government published the first element of its discharge policy, Steps on NHS Response to COVID-19, before publishing a further document dated the 19th of March 2020, COVID-19 Hospital Discharge Service Requirements. And on the 2nd of April 2020, further admissions guidance was published, which stated that negative tests are not required prior to transfers and admissions from hospitals into care homes. Policy recommending both testing and isolation for 14 days for new residents admitted to care homes, whether from hospital or from the community, was not issued until the 15th of April 2020. Counsel for the claimant suggested that all patients discharged from hospital pursuant to the March discharge policy should have been kept in a quarantine facility for 14 days before being permitted to enter a care home. The defendant's response was that this was unrealistic. The facilities did not exist to provide this service for all those discharged. However, in the court's judgment, this was not a binary decision. They said that the 19th of March document could, for example, have said that where an asymptomatic patient is admitted to a care home, he or she should, so far as practicable, be kept apart from other residents for up to 14 days. There was no evidence that the Secretary of State had considered these matters. The court added, those drafting the March discharge policy and the April admissions guidance simply failed to take into account the highly relevant consideration of the risk to elderly and vulnerable residents from asymptomatic transmission. In their judgment, such a provision could and should have been included by the Secretary of State for Health in the March discharge policy. Furthermore, if it was not included on the 19th of March, it could and should have been included in the admissions guidance on the 2nd of April. Even though this provision was included in the 15th of April guidance, the judges said that this was a significant delay at a critical period. The judges added, we considered that the decision to issue the 2nd of April admissions guidance in that form was irrational, in that it failed to take into account the risk of asymptomatic transmission and failed to make an assessment of the balance of risks. In other words, whatever choices ministers take, their primary duty is to keep us all safe. But they didn't.
Well, there seems to be a lot of royal assent since our last podcast, Dennis, with the blink and you'd miss it Judicial Review and Courts Act, together with the Local Government Disqualification Act, which I reported on last podcast, the Building Safety Act, the Elections Act, and the Health and Care Act. Focusing here on the Judicial Review and Courts Act, listeners will recall how critical LRG were of many of the aspects of the initial review, and we of course reflected that in our consultation response. Following a massive response from the legal sector as a whole, the government did remove the proposed statutory presumption requiring judges to award the new suspended and prospective quashing orders in many more cases prior to royal assent. That said, the Act does reverse the judgment in CART and the upper tribunal so that decisions of the upper tribunal are no longer eligible for judicial review. So there you have it. Only time will tell as to what impact these changes create. Now, Dennis, you've been reading an interesting case concerning the government's use of WhatsApp and private emails to conduct government business. What can you tell us?
Well, Helen, yes. You'll remember that during the pandemic, there were several reports in the media that ministers often transacted government business through unofficial channels. Here's the story on the recent case. The Divisional Court has rejected a legal challenge over the use by ministers, civil servants and unpaid advisors of non-government communication systems such as WhatsApp, Signal and private email for government business. However, the court granted the claimants permission to appeal to the Court of Appeal in view of the importance of the issues involved. In the Crown on the application of all the citizens and another against the Secretary of State for DCMS, the claimants argued that the use of these systems and also the use of auto-delete functions meant that public records that should be retained were instead deleted or were otherwise not available to be preserved for the public record. The central issues concerned whether such use was incompatible with the Public Records Act 1958 and the Freedom of Information Act 2000, and second, whether it amounted to an unjustified breach of various policies in respect of the use of communication systems and record keeping. Section 3.1 of the 1958 Act imposed a duty to make arrangements for the selection of public records which ought to be permanently preserved and for their safekeeping. Section 5.3 provided a public right of access to those records that have been put in the Public Records Office. The court, however, rejected the argument that this provision regulated what documents must be retained or how officials communicate before the decision to preserve permanent records is made. In relation to the Freedom of Information Act 2000, the court said that this did not create a duty to preserve any record prior to the point at which someone seeks to exercise the statutory right of access. Now, there were many other arguments raised in this case, but on both these legislative points, I remain uncomfortable with the court's decision. The ease with which incriminating or embarrassing communications can be removed from the public gaze is not what most people would think that the law would allow. Let's hope that this case goes further.
Let's see if it does. Now, mentioned earlier, the Health and Care Bill received royal assent on the 28th of April, which introduces measures, the government says, to tackle the COVID-19 backlogs and rebuild health and social care services from the pandemic, backed by 36 billion over the next 3 years through the Health and Care Levy. Now, listeners will remember that Boris Johnson added a social care cap amendment to the bill through the Commons back in November, despite significant rebellion from Tory backbenchers. Amongst other things, the Health and Care Act is intended to level up health disparities in oral health and obesity, make services safer by establishing an independent health services safety investigations body, ensure our health and social care workforce have the right skills and knowledge to provide informed care to autistic people and people with a learning disability by making specialist training mandatory, introduce regulation of non-surgical cosmetic procedures, and explicitly set out the parity of mental health and physical health, and ensure transparency around spending allocated to mental health support. The Health and Social Care Integration White Paper, published in February, will build on the Act to ensure people receive the right care in the right place at the right time. It follows the People at the Heart of Care White Paper, which set out a 10-year vision for social care funded through the Health and Care Levy and the COVID-19 Backlog Recovery Plan, outlining NHS targets to tackle waiting lists. Dedicated plans to tackle health disparities are set to be published in due course. Now, as you know, Dennis, I'm not one to cast aspersions, but what's all this about being long-winded?
Not me, Helen, but a senior judge has criticised lawyers about their long, drawn-out legal documents. So I've set out some pointers in the next item. Everyone should read the article in the Law Society Gazette by the Master of the Rolls complaining about lengthy court pleadings and documents. Sir Geoffrey Voss said, lawyers draft long documents because they do not take the time to think hard enough about their case to draft short ones. Now, this point set me thinking more generally about the things local government lawyers regularly do: reports to committees, emails, formal letters, and PowerPoint presentations. How much hard thought goes into these, I wonder? Well, here are my personal top tips on all of them. First, let's take reports to committee. The best local government lawyers are held in high esteem for their consummate skills in simplifying complex issues with both precision and brevity. As a general rule, no committee report should be longer than 4 sides of A4, set at Arial font point 11. There can be exceptions, of course. Next, emails. Now, without doubt, email communication is the most misused and overused method of communication. We send them when they're quite unnecessary, and we waste other people's time by filling their inboxes without remorse. If you must email, then no more than 2 to 3 short paragraphs is quite sufficient. But caution, careers have been ended as a result of a thoughtless email, or one sent in anger, or even sent to the wrong person. Now let's turn to formal letters. Formal letter writing is as near to sublime art that lawyers can get in their craftsmanship. Letters remain the most effective and potentially, in some circumstances, the most devastating means of communication, and hence they're still essential at key points in legal practice. Letters can require careful planning and preparation to be done well, and they can hit the spot in a way that no email quite can. 2 pages maximum in most cases is the target. Now, those PowerPoint presentations. Can you remember the last PowerPoint presentation from colleagues that you thought was spellbinding or even absorbing? And that's my point. Most lawyers think they are rather good at these, but in reality they're not. The best lawyers demonstrate quintessential ease when delivering a presentation, and this is born out of both experience and preparation. They know precisely what they're talking about and the messages that they want to get across to their audiences. 40 minutes max, and no more than 10 slides should do it. Otherwise, the presentation will anesthetize everyone. Now, I know that the problem is often lack of time and managing priorities, but taking time to prepare well does pay dividends. And remember, you will be judged by others on how well you do any of these things. As I once said to my principal when presenting a draft for approval, I'm sorry, but I just didn't have time to draft a shorter letter.
Well, no one appreciates death by PowerPoint. However, it's been my experience, certainly in the virtual world, that lawyers really do appreciate a good set of slides. Just not too many, as you say. Now, the Elections Act, as I mentioned before, received royal assent at the end of April, but provisions in relation to voter ID did not take effect so as to affect the most recent elections. The government expects detailed secondary legislation needed for voter ID to work in practice, including the new free voter card, will be passed later in 2022. Voter ID requirements should then be in place for local elections in England in May 2023 and at any UK parliamentary election held after that date. The types of ID to be allowed are set out in Section 5. These include passports, photographic driving licence, biometric immigration documents, and some concessionary travel passes. Free voter cards will be made available for those without any form of photographic ID. Listeners will remember that during the passage of the election bill, opposition parties highlighted concerns that requiring photo ID might dissuade. However, the government points out that voters in Northern Ireland must provide photo ID before they are given a ballot paper. An Electoral Commission research found little evidence that the ID requirements in Northern Ireland have affected turnout, whilst the allegations of personation have been eliminated. Again, this is a wait-and-see situation, but on the subject of the recent elections, LLG extends its best wishes to all our members grappling a change in leadership or indeed now facing no overall control. And on that note, that's it for another edition of the podcast. You can read more on all the items discussed today and many more besides by going to bulletin number 16, available on the LLG website now. And with that, it's goodbye from me.
And from me too.
Thank you for listening. Have a good week.